Okay, I think we're about ready to get started. So first, let me just introduce myself. My name is Patrick Warzak. I'm a student at the University of Akron School of Law. I'm actually in my last semester, just finishing up here, and I'll be taking the bar in February. I've been working with the Seed Clinic for the last 3 semesters, about a year and a half, and specifically was asked to do some research into this new Limited Liability Company Act that the Ohio legislature passed last December, and that takes effect on January 1st, 2022, just a few weeks from now. So in order to go over that, let me bring up my presentation. I've got a PowerPoint presentation that I'd like to share. So I'm going to share my screen, and let me just sort of get into this. The thing that I'd like to focus on today, I mean, this law is nearly 100 pages, covers a lot of material, gets into a lot of minutia. So what I've done is I've identified what I think are the 3 key, perhaps most important or most significant provisions of the new law. And before I do that, before I sort of jump into those 3 specific points or features of the law, let's go through a little bit of background first on just what an LLC is and what a Limited Liability Company Act is. I'll also touch on why the Ohio legislature decided after more than 25 years to completely revamp the LLC law here in Ohio. And then we'll get into those 3 key provisions of the new law. So to begin with, let's just take a look at the fact that every state in the country has a law on the books governing every type of business, actually, not just LLCs, but corporations. So they have the Ohio Business Corporation Act that governs corporations, the Ohio Partnership Act, which governs partnerships, of course, and then the Ohio Limited Liability Company Act, which governs LLCs. So we'll take a look specifically now and focus on the Ohio LLC Act. The Ohio LLC Act exists today under section or chapter 1705 of the Ohio Revised Code. That took effect in 1994. And as I mentioned, in January 1st, just a few weeks from now, the revised Limited Liability Company Act will take effect and will be on the books as Revised Code chapter 1706. When that happens on January 1st, the old law will completely come off the books and the new law will be the Limited Liability Company Act on the books in Ohio. It was developed by the Ohio General Assembly working together with the Ohio State Bar Association. They have a specific corporate law committee, and they used a prototype act that had been developed by the American Bar Association as sort of the foundation and the basis for this. But what they did in their approach was actually keep aspects of the existing law just to make the transition a little bit easier as they put this new law in the books. Like some of the language is the same, for example. Okay, so what are LLCs? Let's talk a little bit more about that. LLCs, Limited Liability Company Act, is one of the major types of business entities, sort of formal legal business entities that are out there. And if you go into business, there's sort of a range of options. Many years ago, there probably weren't as many. You basically went into business for yourself as an individual, which is no formal business entity at all, and or you had the option of being a corporation. But now there's more options available to people. So on the one end of the spectrum, as I said, you can operate as an individual or as a group of individuals in a very informal sort of approach. There's really no business structure to doing that. Or the more formal business entities, obviously more formal. And one of the key differences is that the individual sort of approach means that you're also taxed as an individual and you take on the law. Sorry, I have a little issue with my camera. You take on liability for contracts, lawsuits, and things of that nature because you are effectively the business. On the other end of the spectrum, if you're a formal business entity, that business entity is taxed as an entity. The business makes money, distributes that money in the form of, well, obviously salaries, but also paying dividends and the like. And those are then taxed, but the entity's income is also taxed first. But that entity also provides liability protection for the individual owners, shareholders, and the like, because really it's the business entity that's entering into those contracts. And when there's an issue, there's a lawsuit, people will sue the business. So you really have this sort of range of informal to formal taxation, from the individual to the entity, personal versus entity liability. And on the one end of the spectrum, as I said, when a group of people get together without any formal business structure and they work as a partnership, the other end of the spectrum would be the corporation. So where does a limited liability company, an LLC, fall in this sort of spectrum? And the reality is that it falls pretty much right in the middle. In fact, the concept of the limited liability company originally came from this sort of idea of mixing some of the aspects of partnership with some of the features of the corporation. And that's actually how the original law was created here in Ohio as well. They took some of the partnership law, some of the corporation law, and they sort of, jerry-rigged something together back in 1994. The limited liability company is a relatively formal structure compared to being, a sole proprietor or working in a partnership, but it's much less formal than a corporation. It does provide that sort of protection of liability. That's why it's called a limited liability company. But it features something called pass-through taxation, where much more like a partnership, the individuals basically share the income and then pay taxes on their personal income tax return each year, as opposed to the entity being taxed. So let's talk a little bit more about limited liability companies and how they're governed. The laws and the rules that govern a limited liability company, an individual LLC, comes from two different sources. On the one hand, there's the government, there's the State Limited Liability Company Act, but then there's also the agreement of the people that get together, these members and these managers who form an LLC, will establish what's called an operating agreement. It's effectively a contract amongst themselves and relative to the business as to how they're going to structure themselves, how capital contributions are going to be made, how profits are going to be distributed, and so on. And so anybody operating a limited liability company act needs to have an operating agreement, but also has to be aware of the Limited Liability Company Act in the state to determine what the rules are, what the extent of the rules are that they can have within their own operating agreement. And in many cases, a Limited Liability Company Act, a state law, will have what are called default rules, which basically says that if you govern yourself in your operating agreement, then that will rule in many cases for many issues. But if you don't, if an issue arises and you haven't addressed this in your operating agreement, then you look to the default rules in the LLC Act. Okay, so why, after all these years, remember the original law was enacted in 1994, has the Ohio legislature decided that now is the time to revamp this law entirely? And really it comes down to what you'd expect it to be, right? After 25, 26, 27 years, the reality of limited liability companies has changed. Remember back then, as I mentioned, they took a little bit of the Partnership Act, a little bit of the Corporation Act, and sort of mashed it all together to create this law. And now they can look at it with a fresh sort of perspective, a clean sheet of paper, and say, let's organize this the way that it's just more logical, better language, get rid of some of the redundancy, but also reflecting what actually LLCs look like in the real world. How do they operate in reality? What does that actually look like? This matters. This is actually an important thing because LLCs, as I mentioned before, are one of the major types of business entities that are available when you're starting a business. But not only one of them, they're actually the dominant, most significant entity form basically in every state, but particularly here in Ohio. Just a bit of data to support that. 73%, almost 3/4 of all businesses in Ohio registered as LLCs. In 2019, 2 years ago, more than 87,000 new LLCs were registered in Ohio, representing almost 90% of all the new business filings, which means that that 73% number is only going to grow if this trend continues. So given the significance in terms of how many businesses are registering as LLCs, it's important that the law is clear, is well organized, and again, reflects exactly how LLCs actually operate in the real world. So when the legislature decided to do this, and they were sort of petitioned by the Ohio State Bar Association, really influenced them, kind of identified a couple of people, senators, to be sponsors. They were looking at cleaning up the language and organizing it in a more logical way, as I mentioned, again, reflecting how LLCs actually operate in the real world. They wanted to make sure that the law was both modern, meaning addressing many of the elements of the laws that are common in other states and that are looking forward to how businesses are not only operating today, but are likely to be operating in the future, and business friendly, because Ohio has made a concerted effort to attract business and certainly to keep businesses here, because that's good tax money, that means jobs, and so on. It also, the legislature wanted to ensure that this new law was flexible to be able to accommodate what they now recognize is a wide range of forms, sizes, approaches to running LLCs in Ohio. The reality is that LLCs come in all kinds of shapes and sizes in all kinds of industries, from truly the small mom and pop shop to major companies that have decided to register as an LLC rather than a corporation. And finally, the legislature specifically wanted to support this concept of freedom of contract. As I mentioned before, the source of law and rules governing LLCs is both the state law as well as the operating agreement, sort of that contractual agreement between the members. The government wanted to make sure, the legislature wanted to ensure that the operating agreement was a priority, had a lot of emphasis on allowing the members to decide amongst themselves how they wanted to operate the business, how they wanted to interact with each other, and so on. All right, now let's get into these three, what I have identified at least as what I think are the key provisions of this new law. So number one, in the original law, 1994, if you started an LLC, even up to today, you have to check the box to determine and decide whether you're going to be a member-managed or a manager-managed LLC. The difference is a member-managed LLC means that your people, the people who are the members of the LLC forming it, are basically all hands-on workers. They're going to run and manage this business day to day. The alternative, manager-managed, meant that more like a sort of, this was common in partnerships, is a situation where you might have somebody who's more like an investor, but they're not hands-on involved day to day. So they would be a member as opposed to, or they would be a manager, but they would have managers who are specified as managing the business versus members who are not actively managing the day-to-day business. The reality is that businesses do all different kinds of things in terms of how they're organizing themselves, who's managing, how they're managing, and so on. So again, to accommodate the reality of that, the flexibility, and to really allow the business to simply decide, they said, let's just pick the one that's the most common, which is the member managed, and then basically allow the business owners, the members, to decide how they're actually going to do it if they're going to do something different. So that's number one. Number two, all business owners, directors, in corporations, for example, have what are called fiduciary duties. They have fiduciary duties to each other and to the business. Fiduciary duties means that they are acting almost like a trustee to take care of the business and to act in good faith with each other and, again, relative to the business. The two most common major fiduciary duties that are talked about in business law are the duty of care, which simply means to take care, to act with care. To make sure you have good information when you're making decisions, to pay attention to the business, to know what's going on, and so on. And then the duty of loyalty, which says that you will act really with the interest of the best interest of the business in mind. So you won't necessarily go out and compete against this business. So you're taking care of this business, but then you're competing against it. Under any of these circumstances, in order to fulfill these duties, you have to act in good faith, which means that you are doing as you say you're going to do without some sort of ulterior motive that is actually going to harm the business. You're not going to knowingly violate the law, for example. You say what you mean and you mean what you say. Now, under both the current law and the new law that takes effect in a few weeks, the duty of care and the duty of loyalty, as well as this obligation to act in good faith, are all default duties provided for in both of those laws. The difference is that under the new law, the duty of care and the duty of loyalty can both be waived within the operating agreement between the members of the LLC. So the question, of course, that might arise. So under what circumstance would members of an LLC intentionally want to waive the duty of care or to waive the duty of loyalty? Well, for example, you can imagine a situation where you have a partner who's providing money, as sort of an investing partner, but we're not going to have any expectation out of them that they're going to provide any level of oversight to the business, or that they're going to necessarily be reading the books, reading, the financial statements or anything like that. Maybe it's an uncle who's providing money for the business, so we're going to waive the duty of care in that case. The duty of loyalty. I'm starting a business, but I already have a business that competes, but you want my investment, you want me to be part of this, so let's waive the duty of loyalty because we already know going in that we have this competing business going on over here. So that would be a situation where waiving the duty of loyalty might make sense. So again, it really reinforces the concept of freedom of contract, allowing the members to decide amongst themselves how they want to act. Fine. Number 3, this is kind of interesting. It allows, under the new law, the establishment of what are called series LLCs. Series, and it can be one, it can be many, under sort of an umbrella LLC. So it's a relatively new concept, well, it's a completely new concept here in Ohio because it hasn't even taken effect yet, but this does exist in other states. Delaware, for example, introduced this a number of years ago. The liabilities and the assets of a particular series are sort of kept separate from other series and from the umbrella LLC. So if somebody sues one series, that lawsuit does not allow them to reach the assets of the other series, or again, the LLC as a whole. So question is, how does this look in the real world? Well, got an example. Imagine you have 2 restaurants. Joe is running his restaurant, Lisa's running hers, and they decide to get together and form one business, the intent of running restaurants together. So they have these 2 initial restaurants. Joe is running his, Lisa's running hers, under this new business structure of Joe and Lisa's Restaurants LLC. Now imagine that Joe's restaurant isn't doing nearly as well. Business is not good, and he can no longer afford to pay his rent. Lisa, on the other hand, the restaurant is very successful, making good money, not a problem. Joe's landlord decides to sue for the back rent. He's suing the LLC as a whole. That means that Joe's landlord, through this lawsuit, can access the profits that Lisa is generating because it's all part of one LLC. So if they took this new approach under the new law, and they wouldn't be able to do this today, but they'd be able to do this literally in a matter of weeks. So now they decide to form Joe and Lisa's Restaurants LLC, but underneath that, they set each restaurant up in its own series, Joe's Restaurant Series and Lisa's Restaurant Series. And just as before, imagine that Joe's restaurant isn't doing as well, not making enough money, and he can't afford to pay his rent, while Lisa's restaurant is doing very well. So in this situation, Joe's restaurant liability is exclusive to that series. And that means Joe's assets are also exclusive to that series. That means when Joe's landlord sues Joe's restaurant series, he can only access the assets of Joe's restaurant series and does not have access to Lisa's profits, and also does not have access to any profits that the LLC as a whole might have. So one of the things that you can imagine with this is you can say, well, okay, why doesn't Joe set up one LLC and Lisa sets up another LLC? And that can be done. But then you've got two completely separate businesses. You have separate operating agreements, you have separate registrations, and you have to do that for every one of those. As an alternative, in this case, you have one registration for Joe and Lisa's Restaurant LLC, and you just simply organize those series within your operating agreement. Now, I don't know this for a fact, but I have a reason to believe, based on reading the law completely from end to end and reading a little bit into how Delaware is handling their series concept, there is a difference. The major difference is that in Ohio right now, they're saying, in order to establish a series, you establish a series in your operating agreement, where in Delaware, you actually register those series. The difference is that if you are going to be suing Joe's Restaurant series, you have to know that it exists. So if there's registration in the state for the series, like there is in Delaware, then you would know that. I'm not entirely sure what's going to happen in reality down the road here in Ohio when somebody does go to sue the LLC. Will there be an answer, something in sort of the court proceeding that allows them to identify, the defendant in this case, to identify that we have the series set up and that's the party that has to be named. We're just going to have to see how this actually transpires because it hasn't existed yet, so we don't have any basis for this. And again, the other thing that I know from talking to a couple of the people with the Ohio Bar Association that worked actually, hands-on in putting this new law together, that some of the rationale for the series concept has to do with real estate holdings and some other issues that are going to be more beneficial down the road. Remember, I mentioned that the new law was enacted with the idea of being forward-looking, to be modern and to be considerate of how businesses are going to be operating down the road. And I think the series, this is sort of like the government in Ohio putting their foot in the water or a toe in the water with the series concept, and they'll be expanding and revising it over time. So we'll have to see how this transpires. Well, anyway, that's my presentation for the day. I really appreciate you taking the time to listen to me, and I hope you learned a little bit of something interesting about the new LLC law here in Ohio. Thank you.